Semester 1 Jurisprudence. So, the basic study of jurisprudence is based on 4 basic questions. What is law? What are the sources of law? How is the law binding? And the elements of law. So, what is law? Under this, we have to understand the definition of jurisprudence, the schools of jurisprudence, definition of law, different theories of law and justice, natural law, and the comparative jurisprudence. Under sources of law and how it is binding, we have the definition of state, sovereignty, constitutional law, administrative law, public international law, administration of justice, sources of law, legislation, rules of interpretation, precedent, advantages of legislation over precedent, codification, and custom. Now, coming to elements of law, we have what are the basic elements of law? That is a person, property, ownership, possession, right, duty or obligation, liability, title, and procedure. And this can be substantive law and procedural law. So that is a summary of the jurisprudence paper for semester 1. And let's see on the definition of jurisprudence. The word jurisprudence has been derived from a Latin word jurisprudentia, which means knowledge of law. The Latin word juris means law and prudentia means skill or knowledge. That is how it is, skill or knowledge of law. That is jurisprudentia, and this is a Latin word. Skill in law or science of law. Jurisprudence refers to the elucidation of the general principles of law upon which the actual rules of law are based. Jurisprudence may be regarded as the philosophy of law, dealing with the nature, sources of elements, and functions of law. Jurisprudence is also a study of the fundamental legal principles. Jurisprudence is often said to be the eye of law. It is the grammar of law. It throws light on the basic ideas and the fundamental principles of law. Just to note, this is Anil K. Nair sir's note on jurisprudence and legal theory. That is meant for the semester 1 students of Kerala University. Continuing, in jurisprudence, we mainly study the nature of law, its sources and purpose, and the nature of rights and duties and other questions related to it. Now, how does it help us? It helps us to understand the nature of law. It helps us to understand the different sources of law. It helps us to understand different elements of law. It helps us to understand the basic principles of law upon which the actual rules of law are based. There's the initial 4 questions. What is law? The sources of law, how the law is binding, and the elements of law. We come across these 4 questions throughout the jurisprudence paper, and we can relate every aspect that we study in this paper to either of these questions. Now, for standard definitions, we have Professor Gray. According to Professor Gray, jurisprudence is the science of law, the statement and systematic arrangement of the rules followed by the courts and the principles involved in those rules. According to Professor Gray, jurisprudence is the science of law, the statement and systematic arrangement of the rules followed by the courts and the principles involved in those rules. Now, according to Sir John Salmond, jurisprudence is the science of the first principles of the civil law. Jurisprudence is the science of the first principles of the civil law. The civil law consists of rules applied by courts in the administration of justice. According to John Austin, jurisprudence is the philosophy of positive law. By the term positive law, he means the law laid down by a political superior or commanding obedience from his subjects. Jurisprudence is a philosophy of positive law. By the term positive law, he means the law laid down by a political superior for commanding obedience from his subjects. Austin classified jurisprudence into 2 parts. They are general jurisprudence and particular jurisprudence. The general jurisprudence means the science concerned with the exposition of the principles of law which are common to all the systems of law. Particular jurisprudence refers to the study of basic principles of a given legal system, such as Indian legal system or British legal system. According to Holland, jurisprudence is the formal science of positive law. The term positive law here refers to the general rule of external human action enforced by a sovereign political authority. The term positive law refers to the general rule of external human action enforced by a sovereign political authority. This is according to Holland. While according to John Austin, the positive law means the law laid down by a political superior for commanding obedience from his subjects. Both the definitions of positive law is similar, where John Austin says jurisprudence is the philosophy of positive law, and this positive law is the law laid down by a political superior for commanding obedience from his subjects. And Holland says jurisprudence is the formal science of positive law. Where Austin says it's the philosophy of positive law, Holland says it's the formal science of positive law. And according to Holland, the positive law is the general rule of external human action enforced by a sovereign political authority. So, in both the definitions of positive law, it is stated that it is enforced by a political sovereign authority. According to Austin, it is for obedience from his subjects, and according to Holland, this is a general rule to control over the external human action. But which is common is that Austin as well as Holland both refers to the positive law as laid down by a political superior authority. Austin says it's the philosophy of positive law, and Holland says it's the formal science of positive law. Now, Dr. Setna, jurisprudence is the study of fundamental legal principles, including their philosophical, historical, and sociological basis, and an analysis of legal concepts. According to Setna, jurisprudence is a study of fundamental legal principles, including their philosophical, historical, and sociological basis, and an analysis of legal concepts. So, based on this definition, we get an idea of what are schools of jurisprudence. So, while discussing about the schools of jurisprudence, we have the historical school, we have the analytical school, we have the ethical or philosophical school, and finally the sociological school. So, considering the schools, Dr. Setna's definition is so near to it. According to Setna, jurisprudence is a study of fundamental legal principles, including their philosophical, historical, and sociological basis, and analysis of legal concepts. Going forward with schools of jurisprudence, at various times and places, jurists have made their approaches to the study of law from different angles. They have defined law, determined its sources and nature, and discussed its purposes and ends. There is no unanimity of opinion among the jurists with regard to the definition, nature, sources, purposes, and aims of law. The difference of opinion among the jurists result in different schools of jurisprudence. Firstly, we are looking onto historical school of jurisprudence. Savigny was the chief exponent of historical school of jurisprudence. Savigny was the chief exponent of historical school of jurisprudence. In England, the founder of historical school of jurisprudence was Henry Maine. So, with regards to historical school of jurisprudence, we have Savigny as well as Henry Maine. Savigny is considered to be the chief exponent of the historical school of jurisprudence, while in England, the founder of historical school of jurisprudence was Henry Maine. The task of historical school is to deal with the general principles governing the origin and development of law. According to the exponents of historical school, law is a spontaneous expression of the people and is the result of organic growth. According to the exponents of historical school, law is the spontaneous expression of the people and is the result of organic growth. Law is the spontaneous expression of the people and is the result of organic growth. They examine the growth of fundamental legal concepts and institutions in the background of history. According to them, the law of people grew in the same manner just as its language and manner are formed. Law is a result of Volkgeist, that is, the spirit of people. Volkgeist. So, I'm not exactly sure about the pronunciation of this word. Volkgeist, that is the spirit of people. Law has its foundation in common conscience of the people. Law has its foundation in the common conscience of the people. According to them, law is found and not made. It is self-existent. Law is antecedent to the state and it existed even before the state came into existence. Law is independent of political authority and enforcement. So just to summarize historical school, the main chief exponent of historical school is Savini, and in England it was founded by Henry Maine. So according to them, what they infer is law is the spontaneous expression of the people and is the result of organic growth. And then law is found and not made. It is self-existent. Law is antecedent to the state and it existed even before the state came into existence. Law is independent of the political authority and enforcement. Now, analytical school. Analytical school of jurisprudence. Here we have Austin, Holland, Sir John Salmond, Amos and Mark B. Austin was the founder of this school in England. In England, historical school was founded by Henry Maine and analytical school was founded by Austin. And so, analytical school is also known as Austinian School of Jurisprudence. So, if you come across Austinian School of Jurisprudence, it is Analytical School of Jurisprudence. Analytical school deals with the present situation of law in a legal situation, where historical jurisprudence dealt with the past and the development and how it evolved. Analytical schools deal with the present situation of a law in legal system. The exponent of this school analyzes the first principles of law as they existed in a legal system. This school is concerned neither with the past nor with the future of law, but with the law as it exists. The school is therefore known as positive school. So, the analytical school is also known as positive school. Why? This school is not concerned neither with the past nor with the future of law, but with the law as it exists. The exponents of analytical school of jurisprudence consider that law is a creation of state. Law is treated as a command emanating from the state. This school is therefore known as imperative school. So, analytical school is also known as the Austinian School of Jurisprudence and the Positive School of Jurisprudence and also the Imperative School of Jurisprudence. Why is it called the Imperative School? Because here law is treated as a command emanating from the state. And why is it called Positive School? Because this school of jurisprudence does not deal with the past nor the future. It is concerned only with the present, as the law is law as it exists at the moment in a legal system. That is positive and thus positive school. The jurist belonging to a school takes a developed legal system and proceeds logically to analyze its basic concepts and classify them so as to bring out their relation to one another. It ignores the historical evolution. According to the exponents of analytical school, law is a command of the sovereign and it is a creation of the state. Without a sovereign, there can be no law. The hallmark, that is a distinctive feature of law, is the enforcement by the sovereign. Law rests upon the forces of state. The jurists of this school refused to recognize the impact of legal evolution. The historical school only deals with the legal evolution and considers that as the most prime, whereas analytical school completely refuses to recognize the impact of legal evolution. The existing legal institutions can be supported or opposed only when we know the good and evil behind them and how they worked in the past. So once again, analytical school, Austinian school, imperative school, positive school, it all refers to analytical school of jurisprudence. Now, what are the main difference between analytical school and historical school? Well, analytical school considers law as the creation of state, whereas historical school considers law as what is found and not made. They consider law as self-existent. Analytical school considers law to be from a sovereign. Without a sovereign, there can be no law. Whereas historical school, law is antecedent to the state and it existed even before the state came into existence. As with analytical school, the hallmark or the distinctive feature of law enforcement is by the sovereign. But with respect to historical school, the law is independent of the political authority and enforcement. As for analytical school, the law rests upon the force of the state, while the historical school, the law rests on social pressure. Now, analytical school, when we are interpreting statutes, judges should confine to the letter of the statute, and it's a very rigid and strict form. Whereas historical school, in considering a statute, judges should consider the history of the statute. What was the purpose of the statute? So these are the basic difference between an analytical school of jurisprudence and historical school of jurisprudence. Historical school of jurisprudence, we have Savini as well as Henry Maine. In analytical school, we have Austin, Holland, Sir John Halmond, Amos, and Mark Bain. And analytical school, Austinian school, imperative school, positive school, all are the same. Now, ethical or philosophical school of jurisprudence. The main exponents of this school were Hugo Grotius, Immanuel Kant, Hegel, and Sibling. The philosophical or ethical school considers law as a means to achieve justice. According to the school, the purpose of law is to maintain justice in society. So, as we saw earlier, we had political authority. See, in analytical school, the law had to come from a political sovereign authority. And with the definition we had from Austin as well as Holland, both are from analytical school. What they believed is these law is a form of acquiring obedience from the subject or to control the external human action. Now, when it came to the historical school, their point was just like how the language and manners came into being. It was the human and social actions throughout the ages that came, like that is how law was formed. So law did exist since the time society existed. It is just that we found that such laws are there and it was never made. That was the point of the historical school. So we have discussed both, where a political authority creates law for obedience or to control the human actions, that is the analytical school, and where the law was already existing and we just realize it is there and law was found, that is a historical school. Now coming to ethical or philosophical school, here they say law is just a means to achieve justice. The society needs justice, and to maintain justice we need law. And here in ethical or philosophical school, legal restrictions can be justified only if they promote the freedom of individuals in the society and justice. So, here, the ethical or philosophical school of jurisprudence, which is supported by Hugo Gracius, Immanuel Kant, Hegel, and Sebling. Here, they consider law as the means to achieve justice, and the purpose of law is to maintain justice in society. Legal restrictions can be justified only if they promote the freedom of the individuals in society and justice. This school is neither concerned with the historical past nor with the analytical present, but with the future of law as it ought to be. So that is the base of three schools: historical, where we discuss about the past of the law, and analytical, where we discuss about the present situation of the law in the legal system, and then we have ethical or philosophical, which deals with the future of the law as it ought to be. The main purpose of law ought to be the attainment of human perfection and securing liberty to individuals in the society. And thus we come to the final school, that is a sociological school of jurisprudence. This school developed along with the development in society. That is why it has been said that the historical school laid the foundation on which sociological school has built its edifice. Now, Montesquieu, Auguste Comte, Herbert Spencer, Rudolph von Eyring, and Roscoe Pound are the chief exponents of sociological school of jurisprudence. Montesquieu, Auguste Comte, Herbert Spencer, Rudolph von Eyring, and Roscoe Pound. The exponents of this school are concerned with the impact of law in the society. According to them, an individual has double role and dual interest. An individual has private interest and social interest. Sometimes his private interest may conflict to a social interest, and in such case, more importance shall be given to the social interest and restrict the private interest. The focus of law should be society and its development and not individual. So this is somewhat contradicting to the ethical or philosophical school of jurisprudence, where they say that legal restriction can be justified only if they promote the freedom of individuals in the society. It's not completely contradicting, not completely agreeing to, because in ethical or philosophical school, we discuss about individuals in the society. And here in sociological school, we say that a person will have a private interest as well as a social interest. But considering both the private and social interest, we should give more importance to the social interest. That is, we should try to bring justice to almost like maximum individuals in the society rather than a single individual. So we can restrict the private it can be justified to restrict the private interest if it's done for the social interest. The focus of law should be society and its development and not individual, and individual's interest can be absolutely be prohibited when it is injurious to the social interest. An individual's interest can be absolutely be prohibited when it's injurious to the social interest. So that is the sociological school of jurisprudence. So in historical school of jurisprudence, we have Savigny as well as Henry Maine. In analytical school of jurisprudence, we have Austin, Holland, Sir John Helmont, Amos, Mark B. And then we have ethical and philosophical school with Hugo Gracius, Immanuel Kant, Hegel, and Sebling. And finally, the sociological school with Montesquieu, Auguste Comte, Herbert Spencer, Rudolph von Eyring, and Roscoe Pound. Now, what is law? Definition and functions of law. The term law is used to denote a body of rules to guide human action. The term law is used to denote a body of rules to guide human action. Law regulates and controls the external human conduct backed by the sovereign political authority. So this is very similar to the explanation of jurisprudence as by Holland. Now, what here law is defined as: law regulates and controls the external human conduct backed by the sovereign political authority. Holland's definition of jurisprudence was that it is a formal science of positive law, and there the positive law was something that controlled the human action, external human action based on the political authority, law made by the political sovereignty. So the term law has been defined by different authorities in different ways. Some of the definitions will be like Wilson. According to Wilson, law is that portion of the established thought and habit which has gained distinct and formal recognition in the shape of uniform rules backed by the authority and power of government. So, according to Wilson, law is that portion of the established thought and habit. So, law is that portion of the established thought and habit which has gained distinct and formal recognition in the shape of uniform rules backed by the authority and power of the government. Now, according to Holland, law is a general rule of external human action enforced by a sovereign political authority. So in both these definitions, we have the authority of power and of government, sovereign political authority. So they belong to the analytic, we can say they belong to the analytical school, where Wilson as well as Holland. Wilson said law is that portion of the established thought and habit which has gained distinct and formal recognition in the shape of uniform rules backed by the authority and power of government. Whereas Holland says law is a general rule of external human action enforced by a sovereign political authority. That is a general rule of external human action enforced by sovereign political authority. Now, according to Green, the law is a system of rights and obligations which the state enforces. So, according to Green, the law is a system of rights and obligations which the state enforces. According to John Erskine, law is the command of a sovereign containing a common rule of life for his subjects and obliging them to obedience. Law is the command of a sovereign. So this is the definition of John Erskine. Law is the command of the sovereign containing a common rule of life for his subjects and obliging them to obedience. Now, according to Jeremy Bentham, law is the will or command of the legislator. According to Jeremy Bentham, law is the will or command of the legislator. According to Pound, that is Roscoe Pound, the law constitutes body of principles recognized or enforced by public and regular tribunals in the administration of justice. The law constitutes body of principles recognized or enforced by public. Body of principles recognized or enforced by public and regular tribunals in the administration of justice. Now, according to John Salmond, law may be defined as the body of principles recognized and applied by the state in the administration of justice. So, the definitions of John Salmond and Roscoe Pound is very similar. Roscoe Pound defines law as the law constitutes body of principles recognized or enforced by public and regular tribunals in the administration of justice. As according to John Salmond, law may be defined as the body of principle recognized and applied by the state. According to Roscoe Pound, it's body of principle recognized or enforced. According to John Salmond, it's the body of principle recognized and applied by the state in the administration of justice. Now, according to Professor Gray, the law of the state or of any organized body of men is composed of the rules which the courts, that is the judicial organs of that body, laid down for the determination of legal rights and duties. The law of the state or of any organized body of men is composed of the rules which the courts, that is the judicial organ of that body, lay down for the determination of legal rights and duties. Now, according to Austin, law is the command of the sovereign to his subjects, obliging them to a course of conduct. According to Austin, law is the command of the sovereign to his subjects, obliging them to a course of conduct. The main function and purpose of law has been stated to be achieving justice, stability, and peaceful change in society. Law provides principles for conflict resolution between individuals and groups within a society. Law also provides procedures for conflict resolution. So we have come across the definitions of law by Wilson, Holland, Green, John Erskine, Jeremy Bentham, Roscoe Pound, John Salmond, Professor Gray, and Austin. So according to Wilson, law is that portion of the established thought and habit which has gained distinct and formal recognition in the shape of uniform rules backed by authority and power of government. According to Holland, law is a general rule of external human action enforced by sovereign political authority. According to Green, the law is a system of rights and obligations which the state enforces. According to John Erskine, law is the command of a sovereign containing a common rule of life for his subjects and obliging them to obedience. According to Jeremy Bentham, law is the will or command of the legislator. According to Roscoe Pound, the law constitutes body of principles recognized or enforced by public and regular tribunals in the administration of justice. According to John Salmond, law may be defined as a body of principles recognized and applied by the state in the administration of justice. According to Professor Gray, the law of the state or of any organized body of men is composed of rules which the courts, that is the judicial organs of that body, lay down for the determination of legal rights and duties. According to Austin, law is the command of the sovereign to his subjects, obliging them to a course of conduct. Now, different theories of law and justice. At various times and places, jurists have made their approaches to study of law in different angles. They have defined law, determined its sources and nature, and discussed its purposes and ends. There is no unanimity of opinion among the jurists with regard to the definition, nature, source, purpose, and aims of law. The difference of opinion among the jurists resulted in different theories of law and justice. Jeremy Bentham's theory of law, or Bentham's principle of utility. So, Jeremy's definition of law is the will or command of the legislator. Jeremy Bentham defines law as the will or command of the legislator. Now, Jeremy Bentham's theory of law, which is also known as Bentham's principle of utility. Jeremy Bentham was born in 1748. He died in 1834. His father was a wealthy London attorney. During his lifetime, he studied the good and evil of English legal system. He could realize several defects in English legal system and suggested several remedial measures in order to avoid such defects. He is one of the greatest legal reformers of England. He is the inventor and patentee of legal reforms in England. The theory of legislation and Introduction to the Principles of Morals and Legislation are the most important works of Bentham. The theory of legislation and Introduction to the Principles of Morals and Legislations are the most important works of Bentham. These two works of Bentham convey some of the fundamental ideas of Bentham. These works contain Bentham's moral and legal philosophy, namely utilitarianism. So, Bentham's principle of utility that came up with utilitarianism, and Bentham stressed the need to follow the principle of utility by the legislators. He was of the view that the evil of law could only be avoided or reduced by following the principle of utility. The principle of utility is from Jeremy Bentham. The principle of utility is the only medicine for the lawlessness of law. Definition of law. A law may be defined as an assemblage of signs declarative of a violation conceived or adopted by the sovereign in a state concerning the conduct to be observed in a certain case by a certain person or class of persons who in case in question are or are supposed to be subject to his power. So, a law may be defined as an assemblage of signs declarative of a violation conceived or adopted by the sovereign in a state concerning the conduct to be observed in a certain case by a certain person or class of persons who in the case in question are or are supposed to be subject to his power. The source of law is the will of the sovereign. Sovereign is any person or assemblage of persons to whose will a whole political community are supposed to be in disposition to pay obedience. Every law has a directive and a sanctional part. The former concerns the aspects of the sovereign's will towards an act, situation, and the latter concerns the force of law. A law is dependent upon motivations for obedience. The sovereign's wish in respect of a class of acts is a law as long as it's supported by a sanction. The source of law is the will of sovereign. Sovereign is any person or assemblage of persons to whose will a whole political community are supposed to be in a disposition to pay obedience. Every law has a directive and a sanctional part. The former concerns the aspects of the sovereign's will towards an act situation, and the latter, that is a sanctional part, concerns the force of law. A law is dependent upon the motivations for obedience. The sovereign's wish in respect of a class of acts is a law as long as it is supported by a sanction.